Welcome to REDDY NEUMANN PC Immigration Show. Emily is my business partner, and we are going to present the immigration, the weekly news and weekly updates on the business immigration. Emily, what do we have today?
So the big news last week was the addition to the DS-160, that's the visa application form that you submit at the consulate with social media information. So we'll talk about what that is, what's required, and the impact there. There was also a bill recently introduced into the House, H.R.3033, which has to do with the H4 EAD. So we'll give you an update there, and we'll answer some questions about the process of changing status from H4 to F1, specifically for those that are in H4 as dependent children and aging out, turning 21 and planning to continue their studies in college. And talk about options for non-immigrants to own a business, which status you have to be in for that, whether an H-1B holder can own a business, or what options they have for investment. And as usual, we'll answer your questions live on both Facebook and YouTube. If for some reason we don't get to your question, you can always join our daily conference call. You can go to rnlawgroup.com and get the phone information and the schedule for that, and you can set up a consultation there as well by visiting rnlawgroup.com.
Emily, the social media is the big buzz right now. What is social media? What is social? Is cell phone a social media, or what is a social media? And where did this provision come in to give the information? Who are all supposed to give their social media information? Do they need to give their username and password? Do they need to give you the web link that is there? Do they need to give their names? What if sometimes people use different names? What if they have, sometimes for me to test the Facebook and YouTube, I do have a different account. Before we go into the live, I normally want to test myself, so I use some fake account. So even those things are to be disclosed. What else need to be disclosed in this thing?
Yeah, lots of questions there. So I'll start at the beginning. This is a result of an executive order about kind of national security. This is the same executive order that created the idea of extreme vetting of visa applicants. So it started out with, it wasn't required for everyone. It was only for those that at the consular interview, the officer felt some extreme vetting was needed, and they added this extra form or a questionnaire for only some applicants to fill out. It ended up being about 0.005% of all visa applicants had to fill out this extra form. Now they've expanded that form to where it's required for everyone. So anyone who is applying for a visa at a U.S. consulate or embassy, filling out the DS-160 visa application form, this question will be on the form, and it asks, do you have a social media presence? You have to select from a list of any social media you've used in the last 5 years. Once you click on that social media platform, you do have to provide your handle or your username for that particular platform, but you don't have to provide passwords, you don't have to provide links or anything like that. It's just the handle or username. And it's not all social media. So as far as we can tell, it's a drop-down list, and if it's I don't see an option for other. I do see an option for none. So if you truly don't use any social media, which in this day and age is probably a very small percentage of people, you can answer none. But if you actually do use social media and you answer none, you could be denied a visa not for the social media, but for misrepresentation or potentially fraud or providing a false answer. So you do have to take this seriously. You do have to provide the accurate, truthful information. We know that the typical social media accounts that are required to be disclosed are Facebook, YouTube, LinkedIn, Twitter. Interestingly, I find it funny that MySpace is on there because I'm pretty sure nobody has used MySpace in the last 5 years.
That was a long time ago.
That was like in the 90s, I think, maybe the 2000s. But what else is on there? Flickr, Google+, Instagram, Pinterest, in case they want to know what arts and crafts you like. I'm not sure about that one. Reddit, Tumblr. I don't see Snapchat on the list, which is a pretty common one.
We don't see
WhatsApp on the list, which I guess maybe they think that's not social media. It's more messaging. I don't know, but it is a set list. I don't see a place where they have to put other and then add other platforms that aren't listed. And, you know, one of the big fears that I saw when I posted about this on immigrationgirl.com is people are saying, what are they going to do with this information? Are they going to go through my Facebook posts, and if I said something bad about President Trump, are they going to deny me my visa? No, I don't think that's the purpose. Their whole goal here is to catch terrorists and make sure that they're not being let into the country. So if you have your typical social media that you use, I think the majority of people are not going to be impacted by this other than the hassle of digging through your old accounts to figure out your usernames to make sure that you're answering the question accurately is probably going to be the most difficult thing. I don't know if there's an option to put 2 accounts. Say if you have 2 different Facebooks like I do, I have a personal one and then I have my Immigration Girl one. I don't know if there's a way to put both, and if there isn't, what am I going to do?
I haven't tested it yet, though. Maybe next week we can update the people how, when they have 2 accounts in the same account, how they're going to put in. But at this point of time, if you have a social media account, you are supposed to put in. We're going to update you next week, or probably in our articles, Emily's articles, blog. You can check it out, whether if there are 2 accounts, how you're going to fill that information out. Surprisingly, Emily, WhatsApp, I mean, that's the most used data right now in the world. Seems to be enough all the social media. They left it out. Here is the reason why I think so, that they have YouTube, the Pinterest, and the Facebook, because you can go to website and search that information. But if somebody gives the WhatsApp information, there's no way they can go and search it out. Mm-hmm. That's the reason why I think so, is that why they listed Facebook and YouTube, but not the WhatsApp information. Emily, you made an interesting point that the comments made by the Department of State on having this requirement says that it's 0.005% of the people may have some extreme venting, which the Department of State is interested. 0.005%. That's like out of 100,000, 1%, or like, yeah, approximately 100,000, half a person. So about 200,000, 1%. I may be wrong in my calculation, but and if they are they going to willingly say, well, I'm the person who is supporting this terrorist organization, and here is my web link, and give me the visiting visa?
Right. I mean, that's the kind of silly thing with a lot of these questions, is the people who they're trying to catch are likely not going to answer truthfully. So you're just hassling the people that are willing to answer truthfully and don't have any issues, don't have any reason.
Emily, at this point of time, what I feel is that there is already a 60 to 90 day delays in some of the consulates that are very busy when you're applying for a non-immigrant visa. Now, having these provisions of the social media is going to delay the process of the visas coming into United States. And we have seen that when they introduced the fingerprinting notice for the I-539s, for the H4s and F1s and other visas, they haven't approved a single case at this point of time. I feel that this processing delays for the visas is going to increase significantly. This administration, in its opinion recently, they said that they have no intention to cut down the processing time. At that point of time, we thought, whoa, this looks very odd then compared to the previous administration. Now it feels that it's not only that they don't want to cut it, they want to intentionally delay all the processing, because delaying justice is denying justice. And they cannot directly denying it, they're delaying it. In that way, it is, those visas are not used by any of these people. That's the only reason why I feel this social media has been introduced. On the H.R.3033 bill, which has been introduced in the House, what this is suggesting is that as the Congress people are aware, this administration want to take away the H4 EAD. The House want to pass a bill saying that to pass in the Congress that the H4 EADs should be given employment authorization. Certain H4 EADs, mostly it's the I-140s approved, and all those people who are in the 7th year of the H-1B extension, they should be given EADs. I mean, the same thing which is there in the regulations passed by the Obama administration, which Trump administration is trying to take it off. They want to incorporate in the Congress bill. If that is passed and signed by the president, then they cannot be taken away. The H4 EADs cannot be taken away by this administration. But having said that, it has to be passed in the House of Representatives. It also has to be passed in the Senate, and mostly with a majority of 60 to 40 in there to bypass the to pass it, because otherwise the bill can't be passed in the Senate. And the president have to sign it. I think so. It's very unlikely this H4 EAD bill is going to go through. What do you think, sir, about it?
Yeah, I definitely feel that it's being introduced to appease
certain voters
constituents,
of the.
but I don't think it has a chance of being passed. And really, what we truly need is real immigration reform. We need the per country limit to be
taken
fixed.
off.
If you fix that, you don't need the H4 EAD.
If the Congress has any intention to do any good things for the HR for the people who are stuck in the pipeline, I mean, if they take the per country limit off, I mean, most of the EADs, H4 EADs, we don't need to give them H4 EADs. They have a better solution. They will get their adjustment of status EADs and eventually get the green card, because the waiting time will come down to 2 to 3 years, which is going to be good for all these people. But I think so the way it introduced and the likelihoodness of this bill to be passed is very unlikely. This administration is still thinking of taking the H4 EAD off. They did not publish any proposed regulations by May of 2019. We're expecting those new regulations to restrict the H4 EAD or eliminate the H4 EAD totally will be coming any time. We will update you. There will be a comment period. There will be a final publication period. So there will be a time gap between the time they publish, which they did not yet, and the time gap when the H4 EAD is going to be taken off according to the administration. So of course we will have time to comment and then get back on that, Emily.
All right, so one of the other questions that we get a lot, especially for H-1B workers, is, can I start a business on the side, or can I invest in a business? Can I own a business? So if I'm here on an H-1B visa and I'm working for my employer, and on the side I want to start a website, an e-commerce website, and sell some things.
You said two different things, Emily. You said you want to invest and then you want to open a website. Now, which one are you at?
Well, for now, I want to start a website and start selling things and earn an extra income.
I want audiences to be very careful in these two things. Investment and participation is different. Under limited circumstances, an investment by a non-immigrant visa holder is permissible. For example, if somebody buys an Apple stock, I mean, that's permissible. If they buy in a small company, I would recommend that you check with a lawyer if you can do. But as you said, Emily, that if you're a non-immigrant and you want to open an e-commerce website, and based on that you want to derive some income, I think so that you are working for the particular business, whether it's your business or somebody else's business, you're working for that business. Being an H-1B, you do not have an authorization to open that website and work for that business, Emily. We do get a lot of these questions on when you can invest, Emily. Now, I will ask you some questions where the people, what if I'm an H-1B and I want to invest in a restaurant business? I am not going to be the manager of the company, but I'm going to invest in restaurant. Is that allowed?
So it really depends on your participation level. If you are a passive investor, meaning literally all you're going to do is hand the restaurant $50,000 and you are done, and you take your profit at the end of the year, whatever you make, I think that is permissible. But anything beyond that, anything you're going into the restaurant to check on things, you're helping hire people, you're taking money to the bank from the restaurant, anything beyond.
You're writing a check?
Yes, signing anything is going to be considered unauthorized employment unless you have work authorization to work for that company.
At the most, if you're just going for a free food there, I think so that may be fine. But if you are going there to look into if the employees are working there, is the food is stocked there, or the onions are there, I think so that's definitely a violation of the investment. As a non-immigrant investor, you cannot do that. You just cannot do it.
Yeah, and there are specific visas for investors. That would be the E2 visa, but it's not available to every country. It's only for those that have a treaty with the United States. But that's the type of visa you would need if your country has that treaty. You can invest into a company and actually run the company or bring special skilled individuals to work for your company as long as they're from the same country. So the E2 visa may be allowing that, but if your country of birth, country of citizenship does not fall under the E2 category, then you're on an H1 or an L1, then it's definitely not an option.
Emily, in the change of status to F1 visa, I mean F1 used to be change of status used to take about 2 to 3 months. Now it's taking anywhere between 6 months to 24 months. Can you explain, especially for the people who are going to age out? Age out are the people who can be an H4 until they are 21, but they cannot be an H4 when they are 21, when they touch the 21. They can be before 21. And what if they are filing, they want to move to the F1 visa because they are going to turn 21? What are the precautions that they need to take, Emily?
Yeah, so I think a lot of people assume that as long as I file the application to change status from H4 to F1 before I turn 21 or before I lose my H4 status, that you're fine. And that is a big mistake. People are getting their I-539 applications denied because they didn't take an extra step, which is what's called a B2 bridge application. So what you have to understand about the F1 is when you're issued that I-20 form, it's going to have a program start date. That's the day your classes are supposed to start. And you have to be maintaining your existing status up to within 30 days of that program start date. So if your H4 is ending tomorrow and your program starts tomorrow and you're filing your change of status now, seems like everything is fine, right? No, because while the F1 is pending, that program start date is going to keep getting deferred because you can't approve the change of status to F1 when the start date has already passed. The school is going to keep moving it because the F1 still hasn't been approved yet. Every time they move it, you have to now document that you're going to maintain your underlying status up to the new start date and then again to the next new start date. Well, if you're aging out while that's happening, your H4 can't be extended. So what you have to do is file another application, a change of status to B2 visitor visa to bridge the gap from the end of your H4 to the beginning of your F1 once it finally gets approved. You may have to file 2 of these B2 bridges because you can only request 6 months at a time, and the processing time for the F1 is more than 6 months. So the most important takeaway here is if you're going to be in the situation where you're turning 21 and you're planning on changing your status to F1 to continue your studies at your college, file at least 1 year before you turn 21. Better yet, file 2 years before you turn 21. If you file early enough, you can avoid the need to have all of these B2 bridge applications because your H4 status is going to last for the next year or two. If you are already beyond the 2-year mark and you're getting closer to the point where you're turning 21, just understand that you have to file another application, the B2 bridge. And most importantly, understand that your school may not tell you this. The school, your DSO's job is not a lawyer. Their job, they cannot give you legal advice. Their job is to guide you on this is what you need to go to school here, this is the application that you file. It's your job to figure out all of the stuff in between. So if you are getting to the point where you're getting close to turning 21, talk to a lawyer, make sure you understand what the processing time is and whether you're required to file that B2 bridge. Otherwise, a year later, you could end up with a denial at the end of all of it. So that's very important to know.
We have some quick questions from you from YouTube. Shivam Inamdar has this question. He hasn't got the receipt notice yet under the new quota. What are his probabilities? This is under the 2020 H-1B quota.
So typically at this point, if the filing fee checks that were submitted with your petition have not been cashed, that means you were not selected. Now, every once in a while, people will come to me and say, oh, I got my receipt notice and it's like June. And I always ask, well, did you really just now get it? What was the notice date on the receipt? And come to find out, maybe the attorney got it back in May or April and just now is informing the employee, or maybe the employer actually got it and is just now informing the employee. So it's possible if your employer or attorney is not super fast in updating, or maybe they don't want to inform the people that they filed for until later, that maybe you were selected and they're just not telling you. But if they are telling everybody that's been selected and you haven't been told, that means you were not selected at this point. We've not received any receipts since I think May 13th.
Is it?
Something like that.
So
and
it's
that's
almost
typical.
like
Every year it's around mid-May when we stop getting receipts.
And when are we going to receive the rejections, Emily?
So those typically start in mid-June. So probably in the next 2 weeks we should start seeing those, but it's a very slow process. They've got to send back how many 100,000 petitions. So that goes all the way into August, mid to late August. So all summer long we'll be receiving those return petitions back.
Venu has this interesting political question though, but that question is posed to the immigration lawyers, not to the politicians. He asked this question, Emily, is from YouTube, is that given the backlog of the green cards, and it's going to take more than 100 years for people who are from India to get the green card, can the community sue based on the humanitarian grounds to change the law? Here is it. The country is divided into the judiciary, the legislation, and the executive. You can't go to the court system to change the law. This per country quota backlog system is created by the Congress, which is the legislative. So we cannot go to court system and tell them to change the law. However, I do suggest you, Venu, is that you can petition to the White House and to the Congress to change the law. That's one thing that you can request. The other option is that the administration, through its regulation or through its interpretation, can interpret the law quite a little bit differently than what they are interpreting it. Now, we know the per country limit allows each country, one country cannot take more than 7.1% green card. However, between 1992 to 2002, there were a lot of green cards that were being wasted out because until 2002, the law was that no country can take more than 7%. From 2002 onwards, the law was that if any leftovers were there, they were being given to the 7% of the country. But between 1992 and 2002, there are about 400,000 green cards left over. Now, they can use that, the administration can use that 400,000 and give it to the people right now. That may eliminate the entire backlog system. That's one way the administration can interpret it. So you can approach the president at this point of time and request, depending on how much pressure you and your colleagues are going to put, and we are going to support you in that. That's one thing. The other way that the administration can interpret it differently is, for example, for H-1Bs, only the main applicants are counted. When it comes to the employment-based immigration, they are counting the main applicant and the dependents. The administration can, under certain circumstances, change the policy and then only count the main applicant. In that way, instead of 140,000 green cards, they can issue almost 300,000 green cards. That will eliminate most of the backlog systems in 1 to 2 years. But this is not for the court to take it. The courts won't take those kind of things.
All right, question on Facebook here from Rishvik regarding the H4 biometrics. He wants to know, his wife just gave the biometrics when she went for visa stamping in her home country in December, and now it's time to file the I-539 to extend the H4. Aren't the old biometrics still valid? Unfortunately, no, because those are done with the Department of State. Now it's Department of Homeland Security, and they don't share. Now, could they probably do that if they really wanted to? Yes, but again, as we talked about at the beginning, the purpose of this biometrics, it's not required by law, it's not required by regulation. This is based on an executive order, and the purpose of the executive order is to just delay things.
I have a question, Emily. It's a follow-up question for the gentleman from the Facebook is that, what if the H4 extension was being approved? And now he's going for the extension one more time, and especially if it is within 6 months. You said it's a different department.
Mm-hmm. Yeah, now this time it's a new application.
Come
so
on.
You're going to have to do it again. That's what we've been told, is it's every single time you file an I-539, regardless of whether you just filed one or just did your biometrics, they don't care. Another question from Facebook real quick. Abene wants to know when you can upgrade your H-1B to premium processing. I'm assuming this is for the CAP cases filed in April. So for those that requested a change of status, you can upgrade now. You could start upgrading anytime May 20th or after. We've upgraded a number of them, and those were receipted and not had any issues. It's the ones that are consular processing that can't be upgraded yet, and we still don't have an announcement. We were expecting that sometime this month. So hopefully within the next 30 days here, we'll be able to upgrade for consular processing cases as well.
Shubha has this question from YouTube. He or she has heard mixed reviews with regards to if the I-140 has been withdrawn after 180 days, can you still get an EAD based on that I-140, which was withdrawn after January of 2017 and after 180 days? The answer is clearly you can get an EAD even if your I-140 has been withdrawn, subject to 2 conditions. It was withdrawn after January of 2017. It was withdrawn after it's been approved for more than 180 days. Then you can get an EAD.
Tripty on Facebook filed a change of status from H4 and EAD to H1B and wants to know if the H1B gets approved, can she switch back to H4? And is it possible then to switch back to H1B when the H4 EAD goes away? So yes, the short answer is yes, you can do that. Once you've got your H1B, as long as you've actually entered H1B status by either getting the change of status approved and crossing October 1st or getting the visa stamp, you're considered counted in the CAP. So you can change back to H4 and EAD, and then in the future file a change of status back to H1 without going through the lottery again. Of course, the big issue is practically how do you do it when the H4 I-539 is taking up to 15 months to process. So you have to make sure that you're aware of that timing, and the EAD can't be approved until the H4 is approved. Now we have this biometrics mess involved. So it's not as simple to switch from H1B to H4 EAD, but if you do that successfully, you can later switch back to H1 without going through the lottery again.
Lavanya has this question. How long it's taking for processing the H4 and EAD after the biometrics have been issued? Let me tell you, Lavanya, what I have an answer for. I have no clue how long it's taking. I have no clue how long it's going to take. We have tried different methods, and as of today, not a single H4 plus EAD application, not a single H4 application that was filed on or after March 11th has been approved, even though their spouse's H1B has been approved. REDDY NEUMANN PC is filing a litigation. It will be either filed today or tomorrow, and we are going to file a batch of litigation with regards to the delay of the H4 processing, because the way this administration wants to deny the H4 EAD is by not adjudicating the H4. They introduced this biometric process only to delay. That's the way I am thinking about is that the Congress said that the H4 was supposed to be adjudicated within 30 days. This is if you file in the normal processing. Now, when we filed with the premium processing previously, they used to approve the H4 along with the H1B. Now the USCIS is telling no. They no longer want to adjudicate the H4 along with the H1B. So litigation is the only source. You may want to contact our office if you have an employment authorization and you can't go to work, because if the H4 EAD is expired, you can't go to work. You can go to the federal court, and nowadays when we go to the federal courts, I mean practically all these decisions what they're making are illegal and not that they're not authorized. They're delaying it, so the courts are expected to give judgment in our favor.
The same issue is happening with L2s and L2 EADs as well. So even if the L1 is being approved in premium processing, the L2 is sent for biometrics, and then nothing happens. We contact the premium processing unit and they say you have to call the regular processing customer service or put in an e-request. You try to submit a service request with USCIS regular service, and guess what they tell you? Your case is within normal processing time.
Yeah.
We can't put in a service request right now. They leave you with absolutely no choice. Tried reaching out to the Ombudsman office. I've tried reaching out to the Public Engagement office that did the stakeholder call. No response from anyone. So I think litigation is the best choice at this time.
And you can contact our office or any of the litigation lawyers. They would be able to help you guide on that, because if you're going to purely go, you might have to wait for years for you to get your H4 approval. Pradeep has this question from YouTube, is that he has filed adjustment of status along with the AP and EAD. When can he change the employer? Pradeep, I'm assuming that your I-140 is already approved. Once you file the adjustment of status, if it passes more than 180 days, you can move to a different employer. However, you are supposed to file a 485J supplement replacing your existing employer with a new employer. It's not a complex process. It's a fairly simple process. And we have not seen much problems in the 485J supplement. You asked another question, Pradeep, what happens if you get laid off? If you find a job within a reasonable time with another company, you shouldn't have much problem. Now, I'm not going to explain the reasonable time in this video, but you may want to contact a lawyer with regards to what the reasonable time that you need to find an alternate employer. Now, when you go to the second employer, the job duties that you're going to be doing should be similar to the previous job. So for example, if you are doing a software thing in the SAP, and now you are going to move into .NET, but still in the software development, that doesn't look to be a different job to us. But if you were to move from software profession to mechanical engineer, that definitely looks to be different. And then you may not be eligible for the adjustment of status continuation of your 485.
Question from Facebook, will the I-20 get updated if the F1 student is not in cap gap? So this is again for someone who's filed an H-1B petition in the lottery and wants to find out if they were selected or not. Sometimes you can see that in the SEVP portal because the employment end date changes. My understanding is that does not change unless you're in the cap gap. So in your situation, no, it would not update. Another question from Facebook from Sundeep regarding the social media on the DS-160 form. He's already got a DS-160 submitted. It's all in process, but hasn't gone to the interview yet. Wants to know if he will have to provide the social media information or update the DS-160. No, so it's only for those that have not yet started the form. They will get the new version of the form. If you're already in the process, they're not going to go back and make you resubmit the DS-160 form.
Jayasri Patel has this comment on this. Every day, new ridiculous rules are being brought in. You agree?
Yes, absolutely.
Yes. Absolutely. It looks like, I've been practicing immigration law for 20 plus years. This is more ridiculous things are coming out. And there's no logical reason why they are bringing it. It just doesn't make any sense. And the only reason that I can think about is delay and deny beyond the scope of the law, what they are doing right now.
Swaroop has a question, filed the H4 application, and at the time they got the biometrics notice, realized the first name and last name were switched around. Wants to know how to get that corrected, if it can be done during the biometrics. No, it can't be done during the biometrics. They're actually a contractor. They're not part of USCIS. They don't have access to update records. But you can call the 1-800 customer service number or submit an e-request for a typographical error and request them to update that. You may have to submit your passport if it wasn't already submitted to get that fixed.
Shalini has this question. She's an L2 visa and her I-94 is expiring. She filed for the extension and the extension is pending. How long can she stay in the country after the I-94 expires? You can stay as long as your L2 L2 is not adjudicated. Once the L2 is approved, you're good to stay. If the L2 gets denied, then you have to leave. But you can stay as long as the L2 is pending.
Great question here from Facebook from Treveni. How many jobs can the government save by eliminating the H4 EAD?
Save, they're going to lose more jobs.
I agree.
Because if 100,000 people are employed and they are going to live somewhere, they're going to pay taxes, they're going to eat in restaurants, they're going to go to movies. They will do a lot of different activities with that money. So yeah, it's the other way around, ma'am. It's I would say that the government, we're going to lose. The U.S. is going to lose about 100 to 150,000 100 to 150,000 jobs. 50 to 150,000 jobs will be lost by eliminating the H4s.
Tripty from Facebook wants to know about physical therapist. Does it fall under Schedule A, and how does that make the green card process easier? So yes, registered nurses and physical therapists have kind of a special green card process called Schedule A. What makes it easier is you skip the labor certification. So you go straight to filing the I-140 petition. The idea is that there's such a shortage for nurses and physical therapists that the government has pre-certified that there's a shortage, and the labor certification is already done for you, and you go straight to filing the I-140. You're still subject to the EB2 or EB3 backlog depending on your country of birth, so it doesn't change anything there, but it does allow you to skip the first step.
TD has this question. His wife is on H4 and not EAD. She has a Canadian green card. Can she go every morning to Canada and come back every evening? Is that legally allowed? Will she face any problem? Now, I don't see any problem legally in she going every day to Canada, working in Canada and coming back. I don't see. But if she is staying in United States and working in Canada, that may be the violation. But going every day in the morning and coming back, technically it's not a problem, but it's a nightmare at the time, every time she has to enter into United States. But as such, legally, there's no problem.
Dill from Facebook filed the I-485 employment-based green card with the 765 and I-131 back in December. Still waiting for the EAD and AP. At the time when they filed, the processing times were great, 2 to 3 months. Then it said 3 to 4 months. Now all of a sudden they're saying 5 to 8 months. Spouse is now on OPT, which is expiring, and wants to know what they should do. Should she apply for an H4? So the 485 itself allows you to stay in the country without having the underlying non-immigrant status, as long as you were in status at the time of filing. So she had the valid F1 status at the time of filing. She could technically, at the end of the F1, just stay based on the 485. The risk there is, what if something goes wrong with the 485 and it gets denied? Now she has no status to fall back on. So filing a change of status to H4 can definitely be a good option to allow her to maintain that non-immigrant status. The problem is, if you're planning to file an EAD along with it, now you're stuck with the whole mess of biometrics and the H-4s are not getting adjudicated timely. It's not filed with an H-1B. We're not seeing any fast processing time, so it's very likely she won't get the H4 EAD in time before the OPT ends and may have to stop working until she gets one of the EADs or the other. Potentially, again, litigation may be the route to go. We've tried expedite requests. We've tried to go through congressmen. USCIS just says we don't have the processing, the power, we don't have the capacity to handle all the greater increase in the number of filings and all of that, which is a bunch of baloney, because that's not true. They have plenty of people to process these. Their goal is just to delay everything.
Emily, can you update on the litigation where the USCIS is supposed to respond on the unprecedented denials and unprecedented short approvals?
So there is some ongoing litigation. Kind of multiple companies have filed lawsuits all over the country, and then they were sought to be kind of condensed into one lawsuit in one court altogether, and that is still going on. At this point, they're working on trying to do the discovery process, or actually trying to force discovery, so that the government has to provide some rationale and some documentation, some policy manuals about how it is that they're denying visas that used to be approved when the law hasn't changed. How it is that all of a sudden they can issue a shortened approval when they never did that before and the law hasn't changed. So that's kind of where that's at. It's ongoing. It's going to be a relatively long process because the government is definitely fighting this litigation. So it's at the very early stages.
After 6 years of H1B, move to H4. Can you move back? Can the person move back to the H1B? Yeah, they can. And if they have not applied, I'm assuming that you're going to file a labor and I-140 right now, because if you have used up your 6 years of H1B, the only way you can get back is by filing a labor certification I-140, and you can get back. And on H4 EAD, I'm assuming you have an EAD. If you have H4 EAD, you can file a labor and I-140. Absolutely, you don't have to be on the H1B to file a labor and I-140. But if you don't have an I-140 and you used up the 6 years, you are on H4 right now. You can't move back to the H1B, because if you used up the 6 years and you're now on H4, you want to move back to the H1B, you have to be outside the country for at least 1 year, and then you have to apply in the new quota. To avoid that, I would suggest you to file the labor and I-140, move back to H1B.
Another question along those lines from Satya on Facebook. Currently on H1B, used up 1 year, or I guess used up 4 years, has 2 years left, and is considering leaving the country. Wants to know if after 5 years he can come back in H1B status. Absolutely. So since you've been counted towards the cap, you don't have to be counted again unless you've used up all of your 6 years. Now, in the situation where you are leaving the country for more than a year, you have a choice. You can be cap exempt and not go through the lottery and get only the 2 years that you have left, or you can go through the lottery and get a fresh 6 years because you've been outside the U.S. for 1 year. So you can actually go either way with it, and then if you come in just to get your last 2 years, during those 2 years you can be sponsored for your labor certification, I-140, and then continue getting extensions beyond the 6 year limit.
I want your attention, Emily, on this question from Hiren Modi from the YouTube. He has a mechanical engineering degree, master's degree in mechanical engineering. He has a coursework on data analytics. Can he file as a data scientist and use the coursework to get the H1B?
I think it would really depend on if you can get a good evaluation that somehow combines your bachelor's coursework with this specific coursework to say that you have a bachelor's degree in the relevant field. Typically, data scientist, we've filed under the statistician's code occupation category, and we've had good success with that, but you have to have very specific degree education field of study for that, particularly statistics or math or something close to that. So if you can get your education evaluated to be equivalent to something that's in that field that's required by a statistician, then possibly you could do a data scientist type position. Other SOC codes for data scientists may have a little more trouble.
Here is the main issue though. The H-1B requirement is that you must have the specific degree, not that you must have taken one particular course though. So the argument alone that you have one coursework of the data sciences might not be enough to overcome that you must have the specific degree. You should have additional things that would support to your argument with regards to whether or not you have the specific degree for you.
A couple of questions on H4s and EADs. Nithya wants to know, can the H4 exit the country and go for stamping if the H4 extension gets delayed? So assuming that the H-1B extension got approved quickly like it's supposed to and the H4 is delayed, can you just go out and go for stamping? Absolutely. The issue is we don't know how that's going to impact a pending EAD if the EAD was filed along with it. But yes, you are absolutely eligible to go for H4 stamping based on your spouse's newly approved H1 extension to avoid the wait time on the EAD, on the H4 biometrics. Another question on that, Vijaya wants to know if there is a biometrics fee for the H4 EAD, the C26 category. No, there's no biometrics required for the I-765, which is what you filed to get the EAD. The biometrics is only required for the H4, the I-539. The EAD can't be issued until the H4 is issued, so that's why the biometrics is what's causing the EAD delays, but it's not because the biometrics is required for the EAD. It's delaying the H4, and the H4 is delaying the EAD.
Sveta has this question. She has two questions from YouTube. Is it advisable to move from company A to company B without the approval in hand? Sveta, under the current circumstances, I would not advise that you move from company A to company B without the approval in your hand. The second thing that you asked, Sveta, is it advisable to move for-profit to non-profit? That is fine, Sveta. I don't see that problem. Once you're counted towards the H-1B number, even if you move to the non-profit organization, from there you can move back to the for-profit organization without any problem. It is because you're counted towards the H-1B number in the for-profit organization, you will not have any problem. If you wouldn't have been counted towards for-profit organization H-1B number, it would have been difficult to move from non-profit to for-profit because you have to go in the quota, but now you're counted, you have no problem in moving back to for-profit after you move to non-profit.
Shiv wants to know, can the employer not withdraw the I-140 even though the employees left the company and moved on to a different company? So I'm assuming you're asking, is it mandatory for the company to withdraw the I-140? And no, it is not mandatory. There's nothing in the law requiring them to do so even if you've left and moved to a different company.
Wife has applied from the YouTube. Wife has applied for H4 plus EAD. Can she go for the H4 stamping and come back? Does she need to apply for the EAD again? Yes. The reason is that when you file for H4 plus EAD, you leave the country, it's considered that you abandon the H4 application. Since the H4 application is attached to the EAD, when the H4 is denied, H4 EAD will be automatically denied. So as soon as you come back, you need to file for the EAD again.
Bala wants to know, H-1B is expiring in February 2020 and he's planning to travel to his home country for a vacation. How many days before February 2020 does he have to return? So the rule is that your petition, your I-94, your visa stamp have to be valid on the day you're entering. So technically, if your petition, your H-1B is expiring on February 1st, you could enter up to February 1st and then file the extension. That's the technical rule. Practically, when you do that, you have to be able to convince the officer at the port of entry that you have a job to return to, that you haven't lost your job while you're outside the U.S., and that they intend to file an extension for you. So typically, if I have clients in that situation where they're re-entering close to the expiration of their existing visa, I have them carry a letter from their employer confirming that they will file an extension upon their return. So there's no specific date other than it has to be valid on the day that you're entering, and you have to convince the officer that the extension will be filed and that you have enough time to file that. Would I enter the day before it's expiring? Probably not. 30 days before, that's probably a little better. There's no right or wrong answer to that, though.
Dumney has this question with regards to his old employer's H-1B was being revoked because it's an in-house project. Will he have any problem with the current H-1B that he is in? The answer is yes. If any H-1B has been revoked for fraud, and which it seems to be, when you say in-house, we all know what that is, and people, USCIS also knows what that is. Very surprising, a lot of people think that USCIS doesn't know what in-house you meant. They know it, and when they revoked it, you will have an impact on your current H-1B. Here is the reason. One, because your first H-1B is not counted towards the H-1B number properly. So your subsequent H-1Bs are relying on this H-1B, thus by your further H-1Bs will be revoked. So you definitely are in danger.
Sridhar wants to know if you can switch employers while the H-1B is in process because the current company is shutting down. So I'm assuming this is regarding a CAP case. Your current employer must have filed an H-1B for you in the CAP that was selected and it's pending, and you're wanting to know if you can change employers now. So that's a very tough situation to be in. Until your current H-1B actually gets approved, you haven't been counted in the CAP yet, even though you've been selected. So if you were to try to file a transfer now based on the pending H-1B, and the transfer would likely be denied on the grounds that you're not counted in the CAP yet. So you need to get that H-1B approved, and better yet, you need to wait until October 1st and then file the transfer on October 1st. Now, assuming that you have OPT or STEM OPT or some other work authorization, you can work for another employer because your current one is shutting down right now, and then on October 1st file the transfer to that employer to allow you to continue working from October 1st.
Question from YouTube. He is on 6 years of H-1B, his I-140 is approved. Does he need a new I-140 with a new to file the H4 EAD? Shravan, here is the issue. If you have an I-140 approved and it's not been withdrawn before January of 2017, and it's not been withdrawn after it's been approved for more than 180 days, you do not need an I-140 approval with the subsequent companies that you are going to go. The only reason why you would need the I-140 approval is to eventually get the green card. And for now, if your priority is after 2013, forget about it. It's going to take like 20 years at least to get to that stage. So you are in no need to get I-140 approval from the new company immediately.
Pankaj wants to know what options are available if the H-1B amendment has been denied, but the I-94 is still valid. So the denial of the amendment does not impact the underlying approved petition. So the amendment was filed to change the terms and conditions of employment. So this means if the amendment was denied, you have to go back to the originally approved terms and conditions of employment. So if you can do that, then you can continue to maintain your H-1B status, and the amendment has pretty much no impact on you.
Veena has this question. My daughter I-485, which is green card, has been approved. She hasn't received the green card. Can she travel using the advance parole? The answer is no. She cannot travel using the advance parole. You can make an info-pass appointment and you can go to the local USCIS office. They will stamp her passport for a period for which she wants to travel. And she can travel based on the passport stamping. Typically, it's taking about 3 to 4 weeks to get the green card. But if you still want to go before, I would rather want you to get the passport stamping before she leaves the country. Don't assume that, okay, the green card is going to come in mail, I'm going to send my daughter, and then I'm going to mail the green card to my daughter. Don't do that. That is a big no. So get the stamping. They will stamp it. You go to the local office. It's not much, and normally you don't need a lawyer to do all that. It's called info-pass appointment. You can make it and then get that thing done.
S4 wants to know, is a good question, is it better to file a change of status to F1 to get from H4 to F1, or to go for stamping to get the F1? So stamping is certainly faster, but you run the risk of not getting the stamp. And there are a couple of reasons that could be. One of them is, if you're an H4 as a dependent child, it's possible that you've been in the US for most of your life. And when you're applying for an F1 visa stamp at the consulate, you have to prove ties to your home country when you are applying for that visa, that you are not an intending immigrant. That may be very difficult to do for someone who hasn't lived in their home country for many years. So that's one issue. And then the other issue kind of depends on, other ties to your home country. What if all your family is here? Your parents are probably here on H1 and H4 status themselves. They might have an approved I-140 showing their immigrant intent. You might have a difficulty proving your non-immigrant intent when you're going for stamping. When you're filing the change of status to F1, ties to home country and parents' non-immigrant intent has not typically been an issue, and those have a better chance of being approved. So stamping might be faster, but more risky. Filing the change of status takes a lot longer, takes a lot of additional steps you have to do, but has a higher chance of approval if done correctly.
Vikas has this question, and not a good question. Poor guy has been waiting for green card. He filed his labor certification I-140. His priority date is May 2010, and he's under EB3. How long does he need to wait for him to file the adjustment of status? His H-1B is expiring in 1 year. That's a very tough question. Even though the visa bulletin on the State Department says the priority date for the EB3 right now is April 2010, when you go to the USCIS website, the priority date is actually July 2009. So what does that mean is that only those people whose July 2009 or earlier can file the adjustment of status. It's not actually April 1st either. So there are certain times the date moves. There are certain times USCIS also uses the Department of State visa bulletin to do it. But to give a good guess to you right now, why it's going to take a long time to cross May of 2010 is because the priority date was current until May 1st of 2010 in 2012. So most of the people have already filed the application before May 1st of 2010. There are very less people left out. Now those people who are left out are most of the people are because after May 1st. So when it moves, it might take a long time to touch May 1st of 2010, and it might take a long time to touch each of those weeks that pass by after crossing May 1st of 2010. So I may be expecting that you may have to file for your H-1B extension. Don't rely on the adjustment of status at this point of time. Just file the H-1B extension.
I think we have time for one last question. We'll take this one from Kushal on Facebook. Wants to know if he would require the OPT STEM extension in case the H-1B application has already been adjudicated and approved. Very good question. So it's not required because you've got the cap gap that goes through September 30th and your H-1B will kick in on October 1st. But why would you possibly want it just in case? The most common reason would be in case perhaps you lose your job before October 1st and your current employer withdraws that approved H-1B. If you haven't filed the STEM extension, then that withdrawal puts you out of status. You don't have an option of going back and getting the STEM extension after that point. So that's really the main reason. It would just be as a backup plan if there's any question that you might want to change jobs or any instability in your current job, or just to have it as a backup plan. That would be why you would want to file it, even if it's not mandatory to do so.
Thank you very much for tuning in for REDDY NEUMANN Immigration News. If you want to make an appointment with me or Emily or any of our colleagues, you can check at rnlawgroup.com. Don't forget to subscribe to RN Law Group News and also Immigration Girl blog, which Emily manages it. You can log in for any of the current information. We do also have a daily conference call. You can check our daily conference call, half an hour free for everybody. You can come and ask any questions, and I or any of my colleagues will be there in the conference call. You can find the details of the conference call at RN Law Group. It's a free conference call. Thank you very much. Thank you, Emily.
Thanks for joining.